trying to say members of the jury.
I yell at him all the time.
He's gonna throw pins at you.
I did it
Just make sure you
once.
hit him and not me.
I did it once in the semi round in Carolina, so no, I was like,
We need to have two copies. Because there's two females, like,
I know.
for us,
Three.
three females.
They're like,
But, like, if I had to go and buy more of these little things.
You're being.
They may be nervous first.
You're my
Yeah.
baby.
I'm not here to judge on
in
appearance.
the fitness world,
Better be safe.
I mean, whatever, just ready, I'm
Let's roll.
Good evening, Your Honor. I'm James Hartley,
And my name is Elizabeth Smith.
and we represent the plaintiff in this case. We've prepared a notice of appearance for Your Honor for ease during trial.
Okay.
May I approach?
Yes.
Just a little background on this case, Your Honor. We, in our original complaint, had proceeded on a negligence and a negligence per se cause of action. However, during the course of discovery, we have decided to drop our negligence per se cause of action and proceed purely on a negligence.
Okay.
And additionally, we would like to confirm that this is a standing jurisdiction.
It is. Anything further?
Nothing from the plaintiff,
Okay.
Your Honor.
Anything from the defense?
yes, Your Honor, very briefly, good evening, I'm Jacob Godwin, this is my co-counsel.
Morgan Barham.
Together, we represent the defendant, Petunia Enterprises, and Max Petunia himself. We also have a notice of appearance, if you'd like, I'll hand it up at this time.
Okay.
Permission to approach?
Yes.
And Your Honor, per the rules on page 9 of the packet, pre-trial motions are not allowed, and the defense is ready for trial.
Okay. You may begin with your opening statement.
Before we proceed with our opening statements, there are a few stipulations that we would like to read in.
Okay.
Stipulations 10 through 12. The maximum occupancy capacity for Max's is 250 occupants. Number 11, the maximum occupancy capacity is established by the District of Steelton's Chief of Fire Safety. Number 12, Max's occupancy was exceeded by nearly 30 patrons.
Okay.
And with that, we are prepared to proceed to openings.
All right. You may proceed.
May I please the court? Members of the jury, today is about responsibility, reasonability, and liability. You are here today because on the night of January 7th, on into the early morning of January 8th, 2013, the defendant, Petunia Enterprises, LLC, Montana Max's Good Time Saloon, failed their duty to act responsibly. The defendant, Montana Max's, failed to act reasonably by serving alcohol to a young man named Al Overton when he was visibly intoxicated. Even after the owner of Max's knew Al vomited in the bar, after the owner of Max's saw Al knock over multiple trays of drinks, and after the owner of Max's witnessed Al get into a fight with his best friends on his 21st birthday, the defendant continued to ignore that Al was intoxicated. And so, after serving out shot after shot, after witnessing all this erratic behavior, it was then that the defendant decided to escort Al out of their bar, where Al proceeded to get behind the wheel of his car and attempted to leave the defendant's parking lot. It was as Al was attempting to speed away that he ran a red light leading out of the defendant's parking lot and crashed into a vehicle driven by Quinn Chase. Members of the jury, it's a pleasure to be here with you today. My name is Elizabeth Smith. This is my co-counsel, James Hartley. And together, we represent the plaintiff in today's case, Quinn Chase. Now, today, you're going to hear about what happened at the defendant bar on the night of January 7th and on into the early morning of January 8th. You're going to hear that most people like to call it Max's, and that it's popular with the college students. I mean, it's got games, big TVs, and even bigger drink specials. And on the night of the BCS National Championship football coming to get real cheap food and even cheaper drinks. And on that night, Al Overton, who you're going to hear a lot about today, was at the defendant's. He was there with his best friend to celebrate his 21st birthday. When Al came into the defendant's bar, or to the defendant bar on that night, it was around 10 p.m. And he was there to party. He and his friends planned to take 21 shots to celebrate Al's 21st birthday. They eventually planned to take a shot from each of the 8 shot girls working that night. And when midnight rolled around, when Al Overton finally turned 21, that plan was set in motion. You'll learn today that it was after midnight that Max Petunia, the owner of Montana Max's, personally watched as Al drank at least 4 shots and a beer. You'll learn that the defendant knew Al vomited, watched him knock over trays of drinks, and get into a fight with his best friends. And as Al was being escorted out of the bar, screaming and fighting with the bouncer, Al waved his car keys over his head and announced he was going to another bar. Now, members of the jury, you're also going to hear a lot today about the defendant's shot girls. They're mischievous girls, as they like to call them. These women wander around the bar on crowded nights, such as this one was, with trays of pre-poured shots for the customers. You're going to learn that these shot girls often come and go, and that they're only hired sporadically. You'll learn that these shot girls are not responsibly trained. We don't contend that the defendant didn't have policies and procedures, because they did. They had rules that their regular staff were supposed to follow, but on the night in question, no one took that responsibility. No one at Max's followed the rules that night. For example, even though it's required by the defendant's policies to count the number of drinks that a patron has, no one took that responsibility and counted the drinks that Al had. And even though it is required to call a cab for a patron that they even suspect to be intoxicated, no one at the defendants did a reasonable thing to do. No one even attempted to call Al a cab. Members of the jury, you're also going to learn today that the observation of behavior is one of the biggest signs of intoxication, or the behavior is the biggest signs of intoxication, and that it is required that Max and his staff observe guest behavior. But on this night, they failed. They ignored the biggest signs of intoxication. They ignored Al's sudden change in behavior, his becoming loud and rude, and Al's loss of motor coordination. Members of the jury, you are also going to hear today, you're going to have the privilege to hear from Quinn Chase himself. Quinn is going to get up here and tell you in his own words what happened to him that night. He's going to tell you that earlier in the day, he had a few people over, celebrate the big game. He's going to tell you that, yes, he did have a couple drinks. But pay attention. Pay attention to the number of hours that passed between the time the party started and when the party ended. 7 hours. Pay attention to the number of drinks Quinn had in that 7 hours. Because he'll tell you, he made it a point not to become intoxicated. Because he had a first date that night, and he wanted to make a good first impression, just like we all do on a first date. And he's going to tell you that he's going to go pick up his date from the defendants. And then on his way there, Al Overton spat out of the defendant's parking lot, running a red light, and changed his life forever. That's not all you're going to get to. That's not all who you are going to get to hear from today. You are also going to get to hear from Sydney Crosby, an expert in hospitality and alcohol service. Ms. Crosby will tell you it had been 5 months since the defendant last trained its staff. That it was the defendant's responsibility And Ms. Crosby is also going to tell you that she's also going to tell you how a reasonable bar would have acted when a group of young people came in yelling about doing 21 shots. And then she's going to tell you what the defendant did. She's going to tell you how a reasonable bar would have trained its shot girls. Then she's going to tell you what the defendant did. She's going to tell you what a reasonable bar would have done with a physically intoxicated patron, such as Al Overton. And then she will tell you what the defendant did. Members of the jury, today we have the burden of proof. This is a burden that we gladly take. No, this is not a criminal case. We do not have a burden of proof beyond a reasonable doubt, like I'm sure you've heard about on TV. Instead, our burden of proof is by the preponderance of the evidence, more likely than not. The preponderance of the evidence can be thought of like a scale, and more likely than not means that if the scale even slightly tips in the favor of Quinn Chase after analyzing all the evidence, you must find for Quinn Chase. Now, when it's all said and done, the judge will instruct you on the law. And the law today is simply negligence. Negligence simply means whether a person acted reasonably in order to avoid harming others. Did a person do what they were supposed to do, or did they not do what they were supposed to do? Negligence also means that could mean that a person failed to act where a reasonable person would have acted. And at the end of today's case, you will decide whether the defendant did everything they were supposed to do, or if they failed to do things they were supposed to do. In addition, we must also prove to you that this negligence I've been talking about is the actual cause of the accident, that the defendant's actions or failures to act caused this accident. And if you find that they do, you must find for Quinn. At the end of today's trial, my partner, James Hartley, is going to get to stand up and talk to you one-on-one, just like I'm doing now. And he's going to summarize all the evidence for you. And he's going to show you that you can't just push away the liability. You can't just try to shove the liability onto someone else. And finally, we ask that you pay attention today. Pay attention to all the evidence. Pay attention to the defense. And ask yourselves, are they giving you the whole story? Are they giving you the whole truth? Or are they just grasping at straws? Are they just trying to place the blame anywhere but themselves? Pay attention to Al's behavior. But most of all, most importantly, use your common sense. Because common sense will tell you that it was the defendant's responsibility. It was the defendant's responsibility to act reasonably. And because they failed this responsibility, they failed to act reasonably, it is their liability. Members of the jury, we ask that you hold the defendant, Maxis, liable. Thank you.
Defense?
Your Honor, may it please the court. The plaintiff wants you to think that this case is as simple as ABCs. But they're doing that by relying on assumptions, passing the blame, and jumping to conclusions. What this case is really about is BAC. Good afternoon, members of the jury. My name is Morgan Barnham, and I, along with my co-counsel Jacob Godwin, represent the defendant, Max Petunia. Max is a born and bred Steelton man, just living the American dream. He decided he wanted to give back to the community that gave so much to him, so he opened his own business, Montana Max's Good Time Saloon. Most people just call it Max's. And they'll tell you that he did this to create a fun, safe, and affordable environment for the local college kids. But today, that reputation is on the line. Today, the plaintiff wants you to assume that Max ignored his love of his community and ignored his training. Now, these assumptions stem from a motor vehicle accident that occurred in the early morning hours of January 8, 2013, around 2:30 a.m. Now, earlier in that night, Spring Stream University was playing in the National Football Championship game. And if you've ever watched a football game, you'll know that it starts with a coin toss. And just like that coin has two sides, so does the story. Now, on one side of the story, you're going to hear about Al Overton, how he came to Max's around 10:30 p.m. that night and didn't have anything to drink until midnight when he turned 21. There's going to be a lot of evidence and testimony about how many drinks Al had while he was inside of Max's. You're going to hear this from Al's deposition because he's unavailable for trial, and from Max himself because he told his staff to keep an eye on Al and his party throughout the night. And Max will tell you that based on these observations, he knew that Al was not visibly intoxicated. Now, on the other side of the story, you're going to hear about the other driver involved in the accident, Quinn Chase. You're going to hear evidence that Quinn decided to have a keg party around 7 p.m., but unlike Al, no one was keeping track of how many drinks Quinn had that night. In fact, you'll hear that this accident occurred after Quinn began drinking and while he was on the phone while driving. Now, today it is the plaintiff who bears the burden of proof. And that means they must prove all these claims to you by preponderance of the evidence, which means it must be more likely true than not. So today they must prove that Max was negligent and the actual cause. Now, negligence is based on the reasonable person standard, but it's not based on what I would do in this situation or what the judge would do in this situation. It's based on what a reasonable bar owner and operator would do in that situation. Members of the jury, if you need guidance, the government leaves it out for you. It's in the Dram Shop Act. A reasonable bar owner and operator would not serve a visibly intoxicated person. Now, today you'll hear that Max has strict training and policies in place to prevent serving visibly intoxicated people. It's called the TIPS method. We also expect you to hear some evidence about what other area restaurants use for their training. But the law does not require that Max use a specific training method. The law only requires that the plaintiff prove that Max served out alcohol when he was visibly intoxicated. That is the key language. Now, they must also prove that Max was the actual cause of the accident, which means that absent Max's alleged conduct, this accident would not have occurred. But today we expect you to see evidence that Al Overton himself was the actual cause of the accident. Now, before I go on any further, I want to make one thing very clear. We do not represent Al Overton. He is not a client. And whether or not you like Al should have no bearing on today's case. You're only here to decide whether or not Max bears some responsibility for this accident. Now, we expect you to see evidence about what Al drank inside of Max's, but we ask you to pay special attention to what he drank after he left Max's. We expect you to see evidence that he drank a malt beverage called Mad Dog, that he spilled all over his shirt, and he drank it after leaving the bar, and then he drank. Now, to prove their case to you today, the plaintiff is going to call two witnesses. They're going to call Cindy Crosby, who is the manager of Max's competitor. And when she takes a stand, I want you to keep in mind a few questions. What assumptions is she making? Why is she trying to blame Max's? And what conclusions is she jumping to? Now, they will also call Quinn Chase to the stand. And while he's on that stand, I want you to ask yourselves those very same questions. Now, after they present their witnesses, we will have our own opportunity. But keep in mind, we have no burden. However, we will be raising the affirmative defense of contributory negligence, which means we must show you that the plaintiff himself was negligent in the cause of the accident. And this means that you determine whether under all the circumstances, Quinn acted reasonably to prevent this accident. But today we expect you to see just the opposite, that Quinn Chase did not act reasonably to prevent this accident. We expect you to see evidence that Quinn Chase had a keg party, how he chose to drink, then drive, then answer his phone, and then he got into the accident. So much to ask yourselves. Is that reasonable behavior to prevent an accident from occurring? Now, after their witnesses are done, we will call our witnesses. And the first witness we will call is Max Petunia himself. And he'll tell you a little bit more about his American dream, running a safe and fun environment right here in Steelman. He will also tell you about the TIPS method, what it is, and and what it prevents. And he will also tell you that he's sorry about what happened with him, but how he's confident in his training. And he is confident that that training was used correctly that night. Now after Max, we will call Jean Malkin, an expert in hospitality and the service of alcohol. But I want you to pay careful attention to what she has to say about Al's BAC. And how based on Al's weight and the number of drinks he had, Al did not exhibit signs of visible intoxication. Now members of the jury, what happened on January 8th, 2013 was terrible. But don't let that lead you into making assumptions and blaming an innocent man. Don't jump to conclusions. So I'm before you now, and my co-counsel will be before you again at the end of today's trial to ask you to return the only verdict the evidence supports. Find Max is not liable.
Plaintiff, you may call your first witness.
Your Honor, before we call our first witness, we would like to read in portions of the deposition of Al Overton, who
Okay.
has been stipulated as an unavailable witness today.
Okay, go ahead.
May we ask the questions from the bench and have counsel sit at the witness stand?
Yes.
Your Honor, before we begin, if it's okay with you, we would like to read in portions after they're done.
Sure.
Page 28, line 4 through 12. My understanding is that your BAC was .12.
That's what the machine said, but that thing was defective. The charges were dropped and my name was cleared.
Did you get charged with disobeying a traffic signal and reckless driving, though?
Yes, but I was not going to fight that after avoiding the DUI charges. I did not do anything wrong, but I did not want to tempt fate.
What do you remember about that night? Let's start with when you got to Max's.
We got there around 10 or 10:30. The football game was on and we were getting ready to celebrate my birthday.
Page 30, line 4, and continuing on to page 31 through line 11. What happened with your friends that night?
They were extremely aggressive and rude to the shop girls. They kept trying to grab them and blame it on me. Finally, I had enough and yelled at them and tried to leave.
What happened when you tried to leave?
The bouncers confronted me and I told them to get out and told me to get out because I was harassing the shop girls. I got thrown out.
Did you know Max Petunia?
Sure, everybody knows Montana Max.
Did you see Max there?
Yes.
Did you and Max interact at all that night?
Max yelled at the bouncers to kick me out. Max said he did not need some kid who had his first pop getting sloppy and ruining the night.
What happened next?
I held up my keys and said I was going to Michigan Mike's.
Why did you do that?
Everybody knows Max hates that place. Those two have been involved in some epic battles over customers.
Did you leave right away?
No, I sat in my car for about 20 to 25 minutes trying to cool down.
Did you have anything else to drink?
Do you mean booze?
Yes.
No.
What about the half-empty bottle of Bad Dog in your back seat?
I did not have any of that to drink.
What color was it?
Purple.
And didn't you have purple stains on your shirt when you were arrested?
That was from one of the shots in the bar.
Continuing down to line 16 on page 31. What do you remember about the accident?
Not much. I was sitting at the light. It was red. I looked both ways. I did not see any cars coming, so I pulled out.
You're telling me you did not see Quinn's car.
No, it came out of nowhere.
At this time, we're finished reading in
Okay.
the pertinent parts of that deposition.
You may proceed with yours.
Thank you, Your Honor. Starting on page 27, line 18. So it's your position that you were not drunk that night?
Not even in the slightest. I do not remember much about that evening. I did hit my head pretty bad in the accident. I had a pretty bad concussion.
Moving over to page 28, starting on line 13. Or starting on line 10, excuse me. What do you remember about that night? Let's start when you got to Max's.
We got there around 10 or 10:30. The football game was on and we were getting ready to celebrate my birthday.
Who was we?
Just some of my friends, Steve Barth, Chad Shannon, and Mark Troyan.
Do you know where those guys are now?
No idea, they just kind of fell off the face of the earth. We had a pretty big falling out that night.
Okay, I'll ask you about that in a moment. But first, did you have anything to drink before midnight?
No, sir. Pretty much the whole bar knew it was my 21st birthday. My friends kept telling everybody that I was going to do 21 shots.
That was not the plan.
It was not part of my plan. I just wanted to get my first legal beer and some shots.
Moving over to page 29, starting at line 6. Have you ever had alcohol before your 21st birthday?
A little, a beer here and there. I never had any hard liquor.
Have you ever been drunk?
Maybe once or twice.
Have you ever driven while drunk?
Never.
Not even on the night of the accident?
No, sir, I did not.
Tell me what happened at midnight.
Well, I told my friends that I was not doing 21 shots. That was crazy. So we compromised by doing a shot from each of the shot girls that were working that night. There were 8 or so shot girls working that night.
Do you know how many shots you had?
5 or 6.
And you still say you were not drunk.
I was not. It was over the course of 2 hours. I had a beer that I was nursing the whole time, and I did a shot about every 15 minutes.
How much do you weigh?
I'm about 185.
Is that the same at the time of the accident?
No, I've lost some weight. I was around 225 then.
Your Honor, that's all I have at this time.
Okay. Anything further from the plaintiff
Yes.
on this witness?
No, sir.
The
No, Your Honor.
deposition. Okay. You may call your first witness.
Permission to set up the courtroom for demonstrative?
Yes.
At this time, we call Sidney Crosby to the stand.
Okay.
Your Honor, I would ask permission when they use this demonstrative to reposition.
Yes, that's fine.
Would you prefer me to do it now, or?
Just move whenever they begin to use it.
Thank you, Your Honor.
Could you please introduce yourself to the jury?
Hi, I'm Sydney Crosby.
And what do you do for a living, Ms. Crosby?
I am an alcohol safety training instructor, and I'm also the general manager of a microbrewery called Machine Mike's.
How long have you been an alcohol safety training instructor?
For about 6 years now.
What kind of schooling did you do in order to become an alcohol safety training instructor?
I have my bachelor's in hotel and hospitality management, and I am certified in STOP training.
Could you explain to us what STOP training is?
It's a specific technique for alcohol safety training.
And what does this technique focus on?
It focuses on training employees to identify signs of intoxication, the effects alcohol can have on the body, as well as ways to prevent alcohol-related incidents.
Do you have any other experience in either hospitality or service of alcohol?
I've been working in the hospitality industry for about 8 years now.
And why are you here testifying today?
I was asked to give my opinion about whether or not Montana Max's Good Time Saloon was negligent in serving Al Overton alcohol and about letting him leave the premises on January 8th, 2013.
Did you come to an opinion?
I came to a few opinions.
Before we get into what your opinions were, could you tell us what you looked at in coming to your opinion?
I looked at the defendant Max Petunia's deposition, the deposition of Quinn Chase, and the deposition of Al Overton, the young man who wrecked into Quinn Chase after leaving the defendant's bar, as well as Montana Max's policies and procedures, and the police report that was created that night.
And was that enough evidence for you to be able to come to your conclusion?
It was.
And are your opinions offered within a reasonable degree of professional certainty?
They are.
What process did you use to come to your opinions?
I analyzed what I learned in college to the materials and what I learned from STOP techniques.
Are STOP techniques frequently used in the hospitality industry?
They are. The Stilton Liquor Control Board encourages the use of STOP, and most restaurants in the area do.
Will your testimony help the jury in understanding the evidence today?
It will.
At this time, I'd like to tender Sidney Crosby as an expert in hospitality and service of alcohol.
Any objection?
Your Honor, stipulation 21 of the course packet stipulates that both expert witnesses are qualified, therefore we have no objection.
Okay, then she will be so qualified. You may proceed.
After reviewing all this evidence and applying your knowledge, we're able to come to a opinion on whether Montana Max's acted unreasonably that night.
Yes, it is in my opinion, Montana Max's saloon, then the employees there acted unreasonably on January 7th and January 2013.
What specifically led you to that conclusion?
I identified 3 specific instances of unreasonable conduct.
If we could take those one by one, will you please explain what your first opinion is?
So first, when Al and his friends entered Max's that night, they were bragging about how they were going to do 21 shots for Al's 21st birthday. A reasonable bar owner would have...
Objection to hearsay, Your Honor.
Your Honor, we're not offering this for the truth of the matter asserted. We're just showing this for the effect on the listener.
Okay, what about that?
Your Honor, it was not phrased that way in her answer. She asserted these things as if they happened, they were fact, and therefore they are being asserted to be true.
Rephrase the question and we'll see how it goes.
Move to strike until then, Your Honor.
Sure.
Thank you.
Sure. So could you please explain to the jury what your first opinion was?
So upon hearing that Al and his friends were going to do 21 shots for his 21st birthday, Max staff did not ask Al to leave. A reasonable bar owner would have asked Al to leave because no one can safely consume that many shots of liquor.
Why is it important to ask them to leave immediately instead of letting them stay and making sure that they don't take an unsafe amount?
Well, on that particular night, it was extremely busy. Max's was actually 30 people over the occupancy that the fire chief allows.
Why were they so busy?
Objection, again, is relevant, Your Honor.
Overruled.
Why were they so busy?
It was the night of the national championship game and Mexican Monday.
How does the bar being busy affect your conclusions?
Well, when a restaurant is that busy, employees are not able to keep track of whether people are becoming intoxicated and how many drinks they're having. And so if you already know that someone's going to try to drink an unsafe amount, you should just have them leave before they try to attempt it.
What would a reasonable bar owner have done in situations like this?
Well, first, a reasonable bar owner would have kept the occupancy to what the fire chief allows. And second, a reasonable bar owner would have removed a guest that he suspects to be a danger.
Whose responsibility is it to make sure or to keep track of how many guests are in the restaurant?
The defendants.
And whose responsibility is it to remove any guests that may be dangerous?
It was the defendant's responsibility.
And if we could move on to your second opinion, please explain that opinion to us.
That opinion is that Max's was acted unreasonably for failing to properly train its employees.
How so?
Well, Max would hire on busy nights girls to walk around the bar to sell shots, and they were only hired when needed, and they worked so infrequently and randomly that they were most of the time not trained in any alcohol training safety program.
What does the high turnover have to do with them being properly trained?
Well, Max is only trains its employees every 6 months, and so if a girl was hired in between training sessions, then they were still allowed to, sell shots on the floor without being properly ever trained.
How would a reasonable bar owner have trained his employees?
A reasonable bar owner would make sure that every single employee, including the shop girls, was properly trained by a certified tips instructor.
And whose responsibility is it to make sure that everybody is trained by a certified tips instructor?
It's the defendant's responsibility.
And could you tell us what a tips instructor is?
A tips instructor is an instructor for another alcohol safety program called TIPS, which stands for Training for Intervention Procedures. It's like STOP, but that's the program that the defendant uses.
Is this a program you're familiar with?
I am certified in STOP, but I'm also familiar with TIPS.
How do the two differ?
Well, they're similar, but the Steelton Liquor Control Board, recommends STOP. And most of the restaurants in this area use STOP, but there's no substantial difference.
How would the shop girls being trained by a certified instructor have affected what happened that night?
Well, in his deposition, Max claims that there was enough overlap between those who were trained and those who were not trained. However, shadowing someone who has been previously trained under TIPS is not going to properly prepare them to identify the signs of intoxication and prevent incidents, like someone driving away when they should not be driving. And a TIPS instructor trains employees to determine whether or not an intoxicated guest is going to be driving.
What signs of intoxication did you find that the shop girls failed to monitor?
Well, in the defendant's own deposition, he admitted that while Al was in the bar, he got into a fight with his friends, and then he knocked over a tray of drinks, and then got into an argument with the bouncer, and then actually vomited in the bar.
Showing opposing counsel to mark this as Exhibit D.
Okay.
You reviewed Montana Max's policies, didn't you?
Yes.
Is this a copy of those?
Yes.
Is it a fair and accurate copy of the policies?
Yes.
Have they been altered in any way?
It does, no.
Did you rely on these policies in coming to your opinion today?
I did.
And is that common for experts to look to the restaurant policies and when they're, is it common for experts in your field to look to a restaurant's policies and procedures?
It is.
At this time, I offer trial Exhibit D into evidence as plaintiff's Exhibit 1.
Any objection?
No objection from the defendant.
All right, without objection, it will be entered.
Do these policies explain how to identify intoxicated, or do these policies explain how to identify visibly intoxicated guests?
They do.
Okay. Permission to publish a demonstrative to the jury?
Yes.
If you could step down.
Would you like me to bring these down with me?
Actually, if we could publish this copy to the jury, Your Honor?
Sure.
Could you identify what sections of the policies you found relevant?
So here in section 7.4, this section deals with observation of guest behavior. And the relevant part here is that it says right here that change of behavior is one of the best indicators of intoxication.
Did you come across any evidence of change in behavior?
Yes, so in defendant's, so as I said before, Al Overton came into Max's that night with a group of friends to celebrate his 21st birthday. However, later he got into a fight with the same friends. I would absolutely consider that a change in behavior.
Could you tell us about the next section down there?
So this section deals with the demeanor of the guests and how that can be an indication of intoxication. And the relevant parts here are loud and rude behavior of the guest.
Why are those relevant?
So Al, in his deposition, Max admitted that as Al was leaving the bar, actually getting kicked out of the bar, excuse my language, Al yelled that Max's was an S-H-I-T-T-Y excuse for a bar. I would ask
Objection, Your Honor. On hearsay grounds.
We're not offering this for the truth of the matter asserted. We're not claiming that they were a S-H-I-T-T-Y bar.
Say shitty.
We're not claiming that they are a shitty bar, Your Honor. This is for the effect on the listener.
Overruled.
So that kind of remark I would absolutely consider to be rude and loud and an indication of intoxication.
And what does the last section of 7.4 say?
I'm not that tall, but this is the impaired motor coordination section as a sign of intoxicated person that Max's staff are supposed to look for. And it talks about stumbling, tripping, and spilling drinks as signs of intoxication.
What evidence did you come across that showed that Al was exhibiting these signs?
Well, in the defendant's own deposition, he stated that while Al was in the bar, he knocked over a tray of drinks.
What other evidence did you come across that would lead you to believe that any of the employees there would have known Al was intoxicated?
Well, he also vomited and got into a fight with his friends and was loud and boisterous.
What evidence did you come across that showed the defendant noticed Al was exhibiting these signs?
Well, in his deposition, Al stated that as he's being kicked out of the bar, Max said that he didn't need some kid with his first pop getting sloppy and ruining the night.
And what did this indicate to you?
That Max knew that Al was visibly intoxicated and let him drive away anyway.
And what do the defendant's policies and procedures have to do with what a reasonable bar owner would do?
Well, restaurants' policies and procedures are usually a good indication of what a reasonable bar should do. The defendant had these policies in place, but either chose to ignore them or failed to train their staff properly on them.
So what is your opinion of the policies themselves?
Well, the policies themselves are fine. They are what a reasonable bar would have. However, looking at these policies and seeing that the defendant ignored signs that they consider themselves to be signs of intoxication, it was easy for me to conclude that they were acting unreasonably that night.
Thanks. You can have a seat back on the window stand. Could you please describe your third opinion that you came to?
It was unreasonable on January 8th for Max's staff to allow a visibly intoxicated Al Overton leave the bar, especially since they knew or should have known that he was going to be driving.
What did you come across that indicated that they either knew or should have known he was driving?
Well, as Al was leaving, he waved his keys over his head. And the defendant stated in his deposition that he claims that Al said he had a ride. However, Al in his deposition never indicated that he actually said that. And it's undisputed that he waved his keys over his head, which should have at least been noticed to the defendant to inquire further into whether or not Al was going to be driving.
Do the policies address what should be done in situations like this?
Yes, in section 7.6, they do.
And what does that section say?
That says that you should never let a guest that you suspect to be intoxicated leave the premises.
So what should the defendant have done?
The defendant should have followed their own policies. Their own policies say to have, call a cab or have a friend take them home. And then while their ride is arrived while they're waiting for their ride to arrive, to offer free food and non-alcoholic drinks to the person waiting for their ride.
Who did offer free food and non-alcoholic drinks to Al Overton?
No one,
Who offered to call a cab for him?
no one.
Whose responsibility was it to ensure that Max's customers didn't cause injury to anybody?
The defendants. That's actually reflected in their own policies. In fact, in section 1, it states that Max's staff are the first line in defense in making sure that people have, I can't read it from there, sorry. Okay, 1 second. As employees, you are the first line of defense to ensure that customers have a good time but do not put themselves or other members of the community in danger. They disregarded this part of the policy as well as others.
No further questions at this time. Please answer any questions defense counsel might have.
All right, cross-exam.
Yes, Your Honor. Mr. Crosby, you don't have a PhD, do you?
I do not.
We can't call you doctor here today in this courtroom, can we?
No, I do not, but please call me Mrs. Crosby.
Mrs. Crosby, you don't even have a master's degree, do you?
I do not.
But you do own a bar.
I don't own a bar.
You're the general manager of a bar.
I am.
That bar is Michigan Mike's.
Yes,
That bar is located right here in Skilton,
it is.
right down the road from Montana Max's.
Yes.
Yes. And you would probably agree with me to an extent, your bar, Michigan Mike's, and Montana Max's compete for business.
They do. There are many restaurants in town that are also our competitors, yes.
And even though the two of you compete for business, you're here today to give your fair and unbiased opinion, isn't that correct?
My opinion is unbiased and fair. Yes, it is.
All right, well, let's talk about some of this. You agree that Al Overton did not begin consuming alcohol before 12 o'clock, correct?
It appears unlikely from the evidence, yes.
And you're willing to admit that he had around 6 shots, isn't that correct?
He had at least 5 to 6 shots and a beer, but he wanted to get a shot from each of the shot girls, and there was 8, and he was there for 2 hours, so it could have been more.
But yes, he had at least 6 shots, correct?
Yes.
Now, you're aware that Montana Max's uses the TIPS technique.
They do.
You don't use the TIPS technique.
No, I do not.
But you're not here today saying there's any problem with the TIPS technique.
There is not a problem with this technique, no.
In fact, you are willing to admit that they are essentially the same thing.
They are substantially similar.
Now, you also mentioned Al Overton vomited while he was in the bar, isn't that correct?
He did.
And you admit that that could have been due to bad food, isn't that correct?
It is possible.
You're aware that Al Overton actually arrived around 10:30, isn't that correct?
Yes.
And so he was actually at Montana Max's for an hour and a half before he began consuming alcohol.
Yes.
Don't you think it's reasonable that he had to be doing something within that hour and a half?
Sure.
Now, you said on direct examination that no one at Montana Max's ever offered Al Overton free food. Isn't that correct?
While he was supposed to be waiting for a ride, no, there was no ride to be waiting for.
Well, you're aware it was Mexican Mondays, correct?
Yes.
And you're aware that part of Mexican Mondays is that they offer free chips and salsa to everyone throughout the night?
That could have just been on the table. Doesn't mean anyone offered it to him to sober him up.
Well, if it was on the table, wasn't it there and available for him to eat?
Yes.
Now, I want to talk about what you have to gain from your testimony here today, Ms. Crosby.
I have nothing to give my
You are being paid for your testimony here today, correct?
I am.
And they're paying you to help the plaintiff get a verdict against the defendant. Isn't that correct?
Yes.
You're here to help the plaintiff get a verdict against the defendant.
I looked at this evidence fairly and unbiased, and that's the opinion and my expertise that I came to.
No further questions, Your Honor.
All right. Any redirects?
Yes, Your Honor. Why did you say that it's possible that Al's vomiting was due to a stomach illness?
Well, a staff member had told Max that his stomach wasn't feeling well, that he had eaten bad food or something. And so, yes, it's possible. But vomiting is a sign of drunkenness.
Okay. How did you come to your opinions today?
I analyzed what I learned in college and through the STOP techniques. I analyzed the materials and evidence with the techniques that I learned in STOP and in my education.
And how would you being the manager at Michigan Mike's affect the opinions that you came to today?
I'm just a general manager. I'm salaried. And so, let's say on the off chance that this litigation affected Montana Max's business and some of their customers came to here, it wouldn't affect me. I'm salaried.
No further questions, Your Honor.
Okay. Witness
May the
may
witness
step.
be excused.
Yes. Does the plaintiff have any other witnesses it wishes to call?
Yes, Your Honor. At this time, we call Quinn Chase to the stand.
Okay. You may proceed.
Permission to set up the courtroom.
Sure.
Thank you.
Her Honor, permission to reposition myself once I set up the
Yep.
demonstration.
You don't need to ask. You can just move.
Please introduce yourself to the court.
My name is Quinn Chase.
Tell us a little bit about yourself, Glenn.
Well, I graduated from Steelton State. I was actually a junior there when the accident happened, and right now I'm a graduate student at Springstream University.
Now, Glenn, why are you here today?
I was here, or I am here because I was hit by a driver who was leaving Montana Max's, and I got pretty banged up.
Where were you living at the time of the accident?
I was living in Steelton.
Quinn, we'll get to the accident in just a minute, but first, what else was going on January 7th?
That night was the night of the BCS National Championship game, and my favorite team, Springstream University, was playing in it, and we were all excited, so my roommate and I decided to have people over for a game.
And how many people do you think you had over?
People were going in and out all day, but if we counted up everyone that we saw, probably 75 people.
Glenn, what were people drinking?
Well, we told everyone before they came, it was, it was BYB, bring whatever you wanted, but my roommate and I did provide a keg that night.
I mean, this is a big game, Glenn. I mean, what were you drinking?
That night, I probably had 4 or 5 beers, and I did have one drink from this bottle of Jimmy Runner Blue, some expensive scotch, and it's probably about a shot's worth. But all of this was over the course of about 7 hours.
I mean, 7 hours, so what time did you have your first drink?
We started drinking from the keg around 7 o'clock. But I made it a point to limit my drinking that night because I had to get ready.
Get ready? What'd you have to get ready for, Gwen?
Well, that night was actually the first night I was going to get to hang out with Chris. Chris is this girl I was talking to at that time, and this was really the first time we were going to get to hang out, just the two of us. So I didn't want to make a bad impression.
What time was your date?
We went up later. It was about 2 o'clock.
So, Quinn, how'd you feel driving after having a few drinks earlier in the day?
I was fine. I certainly wasn't drunk. I wanted to make a good impression on my first date with Chris, and yeah, I was fine.
Well, where were you going to get Chris?
I was picking her up at Max's, and then actually on the way, she called me and said that she was leaving. Things were getting a little wild in there, so based on our conversation, we were gonna try and go somewhere else, somewhere a little bit quieter. That way, just the two of us can hang out.
Gwen, I know this is a silly question, but where is Max's?
Max's is in Stilton.
And have you ever been there before?
Yes, I have been one time. It wasn't really a good experience for me. Things were getting a little wild, and I left after my first drink.
All right, so you said that Chris called you. How'd you answer that phone call?
Well, my car at the time actually had a Bluetooth system set up to where whenever my phone rings, all I had to do was press a button on the steering wheel and it would answer it for me. I never had to take my hands off the wheel or even take my eyes off the road.
All right, so you're driving down the road, Chris calls you and changes up plans on you. So what happened next?
Well, I was driving on Route 60, which is the road that Max's is off of, and I'm just following along with traffic, and all of a sudden I was T-boned. Car hit me near the back of my car and threw me to the other lane.
Quinn, I'd like to ask you a couple more questions about this accident.
Okay.
Would it help you to draw out the accident and what happened?
Yeah, sure.
Permission to have the witness step down and
Yes.
help the jury. Now, Quinn, where were you driving that night?
Like I said, I was driving towards Max's, which is right on Route 60.
How many lanes is that road?
This Route 60 through downtown is 2 lanes.
And what are those boxes right up there?
These boxes represent, the one on the far left is Montana Max's. And these 2 boxes here represent the parking lots right outside of Max's.
What if any street lights or signs are there?
Well, there is a traffic signal that regulates this intersection here.
And as you're approaching the intersection, what if anything was blocking your view?
There wasn't anything blocking my view that night.
Well, how'd you know you had the right of way?
Well, not only was I following the traffic in front of me, but I also had the green light at the intersection.
Quinn, how fast were you going?
I was going 30 miles per hour that night.
And what's the speed limit on that road?
35.
All right, so as you proceeded to the intersection, what happened?
Like I said, I went through the intersection. This is my car, and as soon as I went through the intersection is when I was T-boned. The car came out of nowhere.
Quinn, where did your car end up?
Wound up in the other lane.
And what, if any, citation were you given for this wreck?
I wasn't cited for anything that night.
No further questions as of now.
Okay.
Your Honor, permission to preserve for use in closing
Yes.
and permission to enter this as plaintiff's exhibit 1, or plaintiff's,
Any objection to entering this as plaintiff's exhibit 2?
No objection, Your
All
Honor.
right, without objection, it will be entered.
You're a pretty big fan of Spring Stream University, right?
Yes.
And that night you were having a pretty huge party to celebrate, right?
Yeah, we had people over.
You said about 75.
Yeah, if you counted everyone who came in and out throughout the entire day, I think 75 people.
And it was BYOB, right?
Yes,
So these 75 people were bringing their own drinks.
yes,
And you had a keg there, right?
yes, like I said, my roommate and I did provide cake.
That you opened at 7 p.m.
Yes,
And you had some drinks from that keg, right?
yeah,
Okay, now you said you had about 4 drinks, right? 4 beers?
yeah, 4 beers.
Or 5, right?
Yeah.
And you're not 100% sure, are you?
I mean, it's 4 to 5 beers, like I said.
An estimate. Now, in addition to that, you also had a shot of scotch, right?
I had a small drink of scotch, and if I were to guess, it was probably about a shot's worth.
Okay, in addition to the beer you had, right?
Yes.
And then after that drinking, you decided to go on a date, right?
Well, we planned the date. I didn't just find her on my phone randomly.
And that date was at 2:30 a.m., right?
Well, yeah, it was about 2 o'clock, yeah.
Okay, so you get in your car, right, to drive down to Max's originally. That's where you're going, right?
Right.
Okay, so you're on the main road here.
Yep, Route 60.
Okay, and you're familiar with this road, aren't you?
Yeah.
Okay, and you know that it has streetlights all along the way, right?
Yes.
So it's well lit, and there's nothing blocking your view, is there?
Like I said, there was nothing blocking my view.
It's just a straight shot road, right?
Right.
Okay. Now you're driving down this road, and you get a phone call from Chris, right?
Yeah, which I answered on my Bluetooth in my car.
And she was changing locations on you, wasn't she?
Yeah, she said she didn't want to be at Max's anymore because of how loud it was getting.
And this is the same person that you want to make a good impression on, right? You said earlier on direct.
Yeah, this is my first time getting a chance to hang out with Chris, and no one wants to make a bad impression on the first date.
So you're listening to her give you directions to a new place, right?
Well, we were talking about where to go. She wasn't, giving me directions.
So you're talking to Chris, and it was at that point that you got into the accident, right?
Yes.
And you're saying that on that night, on this well-lit road, you didn't see the car until it hit you, right?
No, it hit me in the back of my car, and it'd been hard for me to be looking behind me when the car hit me.
Now, you'd agree with me that it's better to not drink and drive, right? That you should have some beers before you drive, right?
I don't think you should be drunk and drive.
But you think it's okay to have a few and then drive.
Well, it's kind of like having a beer at dinner. I don't think anyone would think that would be bad.
But on this night, you didn't call a friend to give you a ride, did you?
No, I didn't want to bring a friend on my date.
You didn't call an Uber, did you?
No, I didn't call either.
And you didn't call a cab, did you?
No, I did not call her.
No further questions, Your Honor.
Any redirects?
Yes, Your Honor. Quinn, why didn't you call a cab?
Because I was fine to drive.
Why didn't you call a friend?
Because I was fine to drive.
Why didn't you call an Uber?
Because I was fine to drive.
What color was the light when you went through it?
The light was green.
Where did Al Overton hit you?
He hit me in the back part of my car, probably around the gas cap.
Where's Max's in relation to where he hit you?
Max's is Max is right beside the road that he came out of.
No further questions.
All right, witness may step down. Any other witnesses from the plaintiff?
No.
No further witnesses, and the plaintiff's side rests the
Okay.
case.
Anything from the defense?
Yes, Your Honor, this time we would make a judgment as a matter of law or a directed verdict because the plaintiff has not met their burden of proof.
Anything further on that?
Your Honor, excuse me.
What is their burden of proof?
They must show by a scintilla of evidence that the defendant was negligent.
And how have they failed to show that?
They have not shown that Al was served alcohol when he was visibly intoxicated. There's been no evidence of that.
Okay.
Your Honor, we have presented a sufficient amount of evidence to allow a reasonable jury to find that the defendant was negligent we just need to prove that the defendant failed to act like a reasonably careful person would have under the circumstances, and that the harm would not have occurred absent that failure. Today we have heard evidence that Al Overton was displaying physical signs of intoxication while inside the defendant's bar, and was permitted to leave after waving his keys over his head on his way out. A reasonable juror could find that a reasonably careful person would have taken measures to prevent Al Overton from leaving, especially after Al Overton had shot after shot after shot, which you have heard, which the jury has heard, in the defendant's bar. If they had prevented Al Overton from leaving, a reasonable jury could find that Quinn Chase would not have been injured.
Anything else? All right, I'm gonna deny that motion. Let's take 5 minutes and